Hi, everybody. Welcome to this Press Club of Long Island event tonight. We're doing this with the Cornell Law School First Amendment Clinic. Our guests here tonight are Michael Lindhorst, who's the local journalism attorney for the First Amendment Clinic, and Heather Murray, who is the associate director of the First Amendment Clinic and the managing attorney for the Local Journalism Project. We're going to talk tonight about the Freedom of Information Law and Open Meetings Law. They're going to run us through a primer, some training on it. Some of these things you might already know if you've been a journalist for a while, but I'm sure you're going to learn something tonight no matter what. We're going to run for about an hour. First 30 or 40 minutes will be presentation, and we'll leave 20 minutes or so for your questions. Heather and Michael, take it away.
Nice to meet you all. We've done a lot of work with Brendan and Joe and others at Express News Group over the years. As Brendan said, I'm the managing attorney of the Local Journalism Project at the Cornell First Amendment Clinic. The project was founded at the start of the pandemic with my hiring by our clinic's founder, Mark Jackson. Mark's the former general counsel of Dow Jones, and his father actually ran two local papers on Long Island decades ago. He founded the project to help protect, defend, and enable local journalism through providing legal support for investigative reporting, which includes everything from filing a FOIL appeal to bringing a lawsuit to pre-publication review to defending against subpoenas to defending against libel threats. We also support the organizational needs of clients as well, including providing copyright and employment advice, contract review, among other things. Mike and I are going to be focusing today on access to information and access to places, specifically meetings, but we also assist journalists with access to people. We brought a First Amendment retaliation suit recently on behalf of a newspaper that involves a claim that county officials improperly gagged their employees from speaking to the press by saying that all communications had to go through the county's attorney's office. And if you're having that type of issue, please reach out to us. Prior to law school, I was a former journalist for local papers in New York, and this job has sort of brought me full circle. Mike, I don't know if you want to say any more about yourself before we continue.
Yeah, thanks, Heather. Just a brief word about me. As Heather said, I'm the local journalism attorney. And while the Cornell First Amendment Clinic is based in Ithaca, I'm actually based in New York City, and I represent journalists and news organizations around the greater New York metro area. So I'm available to reach out to with any legal issues or questions you might have, whether it's about FOIL and open meetings law issues or anything else that comes up. And also, like Heather, I was a reporter before I went to law school. I worked for the Bergen Record out in New Jersey, covering Chris Christie and state government back when there were a lot of interesting state government issues coming up in New Jersey. So let's continue on and start the presentation.
Up on the screen, we just have a few examples of matters that we handled recently to just give you a sense of the type of work that we do. And I don't know if, Mike, you want to start with Streets Blog.
Yeah, so Streets Blog is an example of one of the clients who we work with a lot on FOIL issues. They will come to us when they've submitted a FOIL to a city or state agency and they haven't heard back, or the agency has denied their request, potentially improperly. We're available to help with filing appeals and then eventually filing a lawsuit if everybody decides that that's the course we want to take. But in this particular case, the Streets Blog DOT lawsuit, Streets Blog was noticing that all of their FOIL requests were getting the same 6-month delay from DOT. They would file a request, and this is the New York City DOT would come back saying, we'll get to it in 6 months. No matter what the request was, whether it was a pretty extensive request seeking a lot of documents or just one seeking an individual document, they got the same 6-month delay. So in this case, we filed a lawsuit against DOT seeking not only the documents that are responsive to the particular request that Streets Blog has submitted, but also trying to get the court to issue an injunction ordering DOT to stop this 6-month delay practice. So it's a pretty novel lawsuit. In the federal FOIA context, there have been some cases where courts have recognized this pattern or practice idea and have ordered a federal agency to cease a pattern or practice that violates FOIA. But in the New York State context, no courts have done that under FOIA yet. So this will hopefully be the first one, and we just filed this lawsuit a month or two ago. So we're in early stages, but we're hoping to make good law and to force DOT to follow its FOIL obligations, which we'll be talking more about in just a moment, all the FOIL obligations that agencies have.
And then we have two other examples up on the screen of FOIL matters. The first one, which was pretty quickly resolved, is one of the reasons why we like to say that we played one small part in bringing down Cuomo. And this was on behalf of News 10. Many of you may recall that there was a question in March of 2021 as to whether Cuomo had taken the required sexual harassment training that he himself had instituted as a requirement for all organizations in the state. And it did turn out, partially through our assistance with News 10 getting access to the sexual harassment training documents, that he had not taken the training for the last 2 years prior to resigning. And there was a question even in 2019 whether he had in fact taken the training or whether it was an aide of his based on the documents that were produced. And that was a case where we put in an appeal on behalf of News 10 after his office had delayed multiple times, continuing to cite the pandemic as a reason for not producing documents well after any agency should have been citing the pandemic as a reason for delay, because we were well into 2021 at that point. So that was a quick win for our client, where we just put in an appeal and 10 days later they produced the documents. The lower left on the screen is a much longer running matter for us. It's the first FOIL matter I took on when I started at the clinic in 2020 on behalf of News Site Documented in New York City. They wanted to create a repository of businesses that have committed wage theft in order to support their immigrant readers in deciding, which places should they work for, which ones should they avoid because of, bad practices. But they were unable to get documents from the Department of Labor that were clearly public. We filed a suit in 2020. That suit got resolved, but because there was an issue with the scope of the request, and Mike will be talking about that later in the FOIL portion here, we didn't get all the documents we wanted through that suit. And so we filed several requests after that, and it took 4 years for this wage theft monitor site to get launched, and we're continuing to work on requests to get more records released. But the site's groundbreaking, and they've gotten some legislation that was proposed by legislators after they did some stories based on analysis of the data. So we were really happy to be involved with that. And then on the open meetings law front, we haven't taken on a lawsuit yet, although we'd be interested in doing that. But we regularly give advice. And back in 2021, one of our upstate New York clients, the Batavian, came to us and flagged that one of the school districts they cover was proposing passing a public comment policy that he had concerns with for a number of reasons. We looked at the policy and said, yeah, we have concerns with it too. If they pass it, there are a number of First Amendment issues with this policy. The biggest one was that it had a paragraph in it prohibiting public discussion of any individual district personnel or students. And the concern there, of course, is that the policy would improperly prevent members of the public from criticizing public officials. And there were several other issues. We ended up putting in a letter to the school district, and they revised the policy before passing it. That was a success, and we're happy to do that type of work for folks as well. And then I'll turn it over to Mike to handle the FOIL portion of the presentation.
Yeah, thanks, Heather. And that's just a sample of the kinds of FOIL and open meetings law cases that we've handled before, and And if any of you are facing anything similar, we're happy to help with in the future. So yeah, I'll talk about FOIL. And then once I go through some of the basics of FOIL, I'll turn it over to Heather to talk about the open meetings law. Now, I can't see any of the attendees, or else I would ask how many people have filed FOIL requests and have dealt with the variety of problems that can come up when you submit a FOIL. So some of this might be review for some of you. Some of it might be new, but I think it's helpful to start from the basics and build from there when you're talking about how best to navigate the FOIL process. And the first basic point to mention is FOIL is the New York State specific records law. There's also FOIA, which is the federal law. And the two laws are pretty similar, but they have some important differences, especially when it comes to deadlines and timing. So I'm going to be focusing on FOIL, the state law. But if you're trying to get documents out of a federal agency, just know that the timing issues may be a little different. So initial questions to ask before you file your FOIL request. You think you might be needing some documents from an agency. And the first question to ask yourself is whether those documents are available without filing a FOIL request. Surprisingly often, they are. Somebody else might have requested the same documents and posted them online. Sometimes agencies will post documents themselves. So doing a little investigation online can end up saving you a lot of time, because if you can get the documents without filing a FOIL request, then it'll obviously be a lot quicker. But step two, if you can't find the documents already available, you'll need to figure out which agency maintains the records, because there's not a general, state email address to submit FOIL requests. You have to submit your request to a particular agency. So obviously you need to submit it to the agency that actually has the records you are looking for. And that raises the third question, whether these records actually exist. FOIL applies to existing records. It entitles the public to access documents that are held by government agencies, since these are public documents. But it does not require agencies to create new records. So a lot of times people will say, well, I want this, statistic, the number of speeding tickets issued by a particular agency. And maybe that agency has a document that contains that number already, in which case you can request that document and hopefully get it. But if there's not a document containing that particular statistic or particular information you want, the agency is not required to compile the statistics and create a new document to give you. So sometimes agencies will respond to a request saying, well, we don't have a document that meets your request. And, a lot of times that response might be inaccurate, and we can go through the process of dealing with appeals and filing a lawsuit to actually get documents that do in fact exist. But sometimes when agencies say they don't have the records you requested, it's because they don't currently exist, and the agency would have to create it, which they're not required to under the law. So that's another question to ask, whether the records already exist. Then another thing to think through is whether the records you're seeking are arguably exempt from disclosure. And I'll talk in a few minutes about the different exemptions that FOIL has. But in general, the way the law works is all public records are public, are accessible to the public through FOIL requests, unless they fall into one of a few narrow exemptions, in which case the agency can withhold the records. Now, this is often where we end up litigating issues, where an agency says a document is exempt from disclosure and we say it's not. But sometimes you can get around this problem right from the get-go. If you anticipate that an agency is going to claim an exemption over one set of documents, maybe there's another set of documents or another way of framing your request to get around that exemption. So you can get basically what you want without having to fight the agency for documents that it thinks are exempt from disclosure. That doesn't work all the time. Sometimes you really need documents that the agency thinks are exempt, but sometimes if you think through this question at the start of your request, you can avoid a lot of hassle. Then the last question to ask initially is, are you prepared for potential denial or delay? And as we're going to talk about, delays are endemic to FOIL. They're really very common. I mentioned the DOT delays of 6 months across the board, and that's kind of an extreme example, but many agencies will delay requests by many months. Sometimes, depending on the agency, depending on the request, you might be facing years of delay. So FOIL generally isn't going to get you documents that you need for reporting like today or tomorrow. You generally do need to be prepared for some delay. Okay, those are the initial questions to ask. Then once you've thought through those issues, we're up to the stage of actually writing the request. And the key thing for FOIL requests is to be as specific as possible. The more specific, the better, both because it's going to increase the likelihood that you get the actual documents you want, but also the more specific you are, the more likely the agency is going to respond in a timely manner, because the agency is not going to look at your request and think, oh, this is voluminous, this is going to take forever to search for. It might be less likely to look for excuses to deny your request if it thinks it can just get the documents and get them back to you quickly. So when we talk about being specific in a FOIL request, we're thinking about things like time frame. Whenever possible, give the time frame of the documents you're looking for. Say the time frame of my request runs from January 1st, 2021 to January 1st, 2022. Whatever time frame you can give to narrow the scope of the search for the records you're looking for. And then, if you can name individuals, for example, if you're looking for emails and you can say, I want emails sent to or from this person, that's really helpful. Subject matter, narrowing the scope of the subject matter as much as possible is going to be helpful. And keywords. If you can give the agency actual keywords and say, okay, plug these keywords in as search terms when you're searching employee emails or databases, that's also going to be helpful to narrow the scope of your request. And kind of as part of how to narrow your request, it's often a good idea to do some research about how the agency maintains the records. What folders are they going to be in? What offices within the agency are likely to hold the records? Oftentimes, a great trick for filing FOIL requests is if you know the name of the form that police officers or whoever have to fill out, and that form is going to have the information you're looking for, you can just request that form by name, a AO 574, whatever the technical name of the form is. And that really helps to make your request really specific and increase the likelihood that the agency will respond to it. Then it's also often helpful to ask for a particular format for the documents to be sent back to you. If you're asking for a database or you want to do some sort of data analysis on the records, you might want it in CSV format or as an Excel. You might request that the documents be sent electronically as PDFs to head off the possibility that the agency will, try to fax them or mail them to you. And then also, as you're writing your request, it's often helpful to cite the applicable response deadlines. We'll talk more about that in just a second, what the response deadlines for FOIL are. But just as a reminder to the agency that they have these deadlines, you're aware of them, and maybe it suggests that you are willing to enforce your rights under FOIL. Next, you can ask for a fee waiver. Certain groups of people are entitled to fee waivers under FOIL, and that includes journalists. You can include a request for a fee waiver in your FOIL request, and generally the agency will agree not to charge you fees. And then finally, before you file your request, just go through it one more time with a fine-tooth comb, because one thing that often happens is requesters will, make a typo or frame their request in such a way that the agency has an easy excuse for denying the request. One example that has come up a couple times in the past is requesting documents about a famous person who goes by like a stage name. And the request might say, I want all documents containing, the person's name and the stage name. And it may be that there are no documents that contain both of those terms. And what you should really be asking for is documents that contain the person's name or their stage name. So little things like that, the and versus or, can end up making a big difference. And if you can catch those sorts of issues early on, rather than waiting for the agency to reply and then having to figure out what to do from there, it'll save you a lot of time. So always go back through the request and really think about it carefully before you file it. All right, so here's a quick example. It highlights a number of potential problems that can come up as you're writing a request. So this request says, we're writing a story this week about racial and ethnic minorities being disproportionately affected by COVID. Could you send me any and all statistics relating to this topic? And there are a number of issues with this request. One, it's very broad, and it doesn't relate to any specific document. So an agency is likely to deny it because it's too vague for the agency to really figure out which documents the requester is looking for. And it may be that because the requester is asking for any and all statistics, the request may be asking the agency to create records that don't currently exist, which is also not something that the agency is required to do. There's also no time frame here, no indication of where these records might be kept, what offices within the State Department of Health might hold them. It's just a very broad, vague request that is likely to get a denial. And if not a denial, then the agency is likely to spend a long time trying to figure out how to respond to it, and you'll be facing a long delay. So better examples of specific requests are these two. And these come from the lawsuit we filed on behalf of Streets Blog. The first one gives a little background at the start. It says, in October 2023, Mayor Adams ordered more outreach to these residents. The residents were surveyed via an online questionnaire. We're requesting the results of that survey and the raw responses on which it was based. And then it also gives a link to an article with more information in case the agency needs additional background for some reason. So this is specific in that it is referring to an individual questionnaire that we don't have the exact time frame of when the residents were surveyed by the questionnaire, but we have a general time frame of when this happened. And the request seeks specific documents, the actual results of the survey and the raw responses. So this is a pretty specific targeted request that, if DOT didn't take so long and impose the 6-month delay, should have gotten a pretty quick response. And same with the second request down below, seeking the commissioner's official calendar for one specific date. That's also a nice, clear request. You know what part of DOT you're going to find it in because it's the commissioner. You know what you're looking for, what type of document, the official calendar, and the exact date. So that's the kind of clarity that is typically helpful for FOIL requests. So I mentioned the timing requirements. Once you file your FOIL request, the agency is going to have 5 business days to respond. And what the law says is in 5 business days, the agency has to grant the request, deny the request, or provide a written acknowledgement that it received the request and give an approximate date when it will grant or deny your request. In practice, agencies pretty much always go with number 3 here. They just acknowledge the request and then give an approximate date. that's the first thing to look out for. Once you file your request, within 5 days, you should be hearing something at least from the agency. And if you don't hear anything, even an acknowledgement, that's a situation where you'll probably want to follow up to A, make sure the agency got it, and B, push them to actually respond. Then after they respond within the 5 days, you're in a little bit more of a no man's land where the agency will give you an estimated date where they'll respond to your FOIL request. They'll often then extend that deadline, sometimes multiple times. And FOIL doesn't give a precise deadline in which the agency does have to grant or deny your request. Unlike the federal FOIA, which has a 20-day deadline, although federal agencies often ignore that as well. But in FOIL, the deadline that the agency sets for itself just has to be reasonable. What that means is a little bit up for interpretation. Oftentimes, agencies don't set reasonable deadlines, or they extend their deadline multiple times, even though state law does not allow for that. But that's something to be aware of, that after that 5-day acknowledgement, you might be in for a bit of a wait. Now, if you're waiting too long, if the agency sets an unreasonable deadline for itself to respond, or if it keeps extending the deadline, or if it misses its own deadline, then you have an option to file an appeal as a constructive denial. You can appeal the agency's lack of response and say that they've constructively denied your request because they're taking an unreasonable amount of time. Sometimes filing those sorts of appeals can push the agency to actually respond to your request. Sometimes they're helpful. Sometimes the agency just continues ignoring it. But if the agency does respond to your request, either denying your request or granting it and giving you documents, then you have 30 days to file your administrative appeal if you don't like the decision the agency made. And how these administrative appeals work, you file an appeal to the same agency and you explain why you think the agency's decision was wrong. Appeals are something that we often help clients with, but it's not something that you actually need a lawyer for. You can write an appeal yourself and just explain why you're appealing. Why, for example, you think that the agency's response time was unreasonably long, or why you think the agency improperly denied your request, or why, even though the agency gave you documents, you think that you didn't get all the documents you were entitled to, or the redactions were unreasonable, or whatever the case may be. So you have 30 days to file the appeal. And then once you file the appeal, the agency has 10 days to decide the appeal. Once you have filed the agency appeal and it's been decided, if you are still dissatisfied with what the agency's done, that's when you can file a lawsuit. And you have 4 months to file a lawsuit after the agency has decided your appeal. So I mentioned the exemptions. All documents held by agencies are public documents accessible to the public unless they fall into one of these exemptions. And I'll just go through them pretty quickly. The exemptions include documents that would be, whose release would constitute an unwarranted invasion of personal privacy. And this is a common exemption agencies cite. It's kind of tricky because of the term unwarranted. It results in kind of a balancing test that courts apply. How much is the document invading somebody's expectation of privacy versus how important is the document to the public's understanding of the government? So there's this balancing test to decide if the invasion of privacy is unwarranted. Another exemption, if the document would impair present or imminent contract awards or collective bargaining. A third exemption for documents containing trade secrets or documents that, if they were disclosed, would cause substantial injury to the competitive position of the subject enterprise. And just a word on that personal privacy exemption. It used to be that police disciplinary records were not subject to public disclosure under Section 50A of the Civil Rights Law. As many of you probably know already, a few years ago, that section was repealed. So now police disciplinary records should be accessible to the public. Oftentimes, police departments are still fighting to keep them secret. But with the repeal of this law, we have a lot more arguments for why you should be able to get disciplinary records. And there have been some really notable successes where news organizations have been able to get them. Other exemptions, a big one that police agencies often use is this one for records that were compiled for law enforcement purposes. But the exemption requires not only that the document be compiled for law enforcement purposes, it also requires that the document's disclosure would do one of these things: interfere with investigations, deprive a person of right to a fair trial, etc. So an agency has to be able to establish both elements, that is compiled for law enforcement purposes and its disclosure would do one of these things in order for the agency to withhold the record. Another exemption that's often used, interagency or intra-agency materials. Those can be withheld from disclosure with some exceptions. So there are exceptions to this exemption. If a document is an interagency material, but it contains factual information, statistical or factual tabulations or data, then it still has to be disclosed, even though it's an interagency material. And there are several other exemptions too. Other exemptions to public disclosure: if the document's disclosure would endanger the life or safety of a person, the agency can still withhold it. And this is a duplicate, the trade secrets exemption, as I mentioned before. Other exemptions, examination questions or answers that are requested prior to the final administration of those questions. Documents whose disclosure would jeopardize the capacity of an agency that has shared information with an agency to guarantee the security of its information technology assets. So a lot of IT-related documents can be withheld under this exemption. And then the last one is for photographs or video created under this vehicle and traffic law. So it's basically red light cameras and things like that don't have to be disclosed under FOIL. So those are the exemptions under FOIL, and oftentimes that's what you're fighting about when you appeal an agency's decision. The agency will say, we don't have to disclose records based on this or that exemption, and then we fight about whether the exemption actually applies. If we get into litigation, so you've filed your administrative appeal, you're still not satisfied, you decide to file a lawsuit, then one of the penalties that the law imposes on agencies that refuse to follow their FOIL obligations are attorney's fees. If you win your lawsuit, you can get attorney's fees. And in some cases, they're mandatory. The agency has to pay your fees. In other cases, they're discretionary. And it depends how the lawsuit turns out. But that's meant as an incentive to the agencies to follow the law. And it's also intended to encourage attorneys to represent FOIL requesters in these kinds of cases. We at the clinic do it pro bono, but there are other attorneys out there who will do it in anticipation of these attorneys' fees. So that's all for FOIL. I'll turn it over to Heather for the open meetings law.
Great. And because the public and the press have the right to know what their government is up to, New York has the open meetings law to ensure that meetings of public bodies are open to the public. And this is the key language from the open meetings law, which seems simple enough when you read it. Every meeting of a public body in New York is required to be open to the general public, except where executive sessions are allowed. But I'm sure I'm not the only one who has been kicked out of a public meeting. And I vividly recall the first time that happened. It was for the Finneran Committee in the town of Greenberg, which was dealing with who should pay for parks in that town. There were unincorporated parts of the town and villages in that town. And the committee was made up of residents. And I had been invited to come to the meeting, but then was kicked out at the beginning of the meeting and told it was not public because it was a purely advisory committee. And purely advisory is a reason why a committee would not be public, but I didn't know that at the time. I didn't know much about the open meetings law and was quite upset to be kicked out of that meeting, and might have argued against it better if I knew the law surrounding this. And this actually came up, this issue came up very recently. I don't know if anybody has been following the 514 Memorial Commission that the mayor of Buffalo put together with Governor Hochul after the top shooting, and that's related to creating this memorial. And they had several meetings after the commission was put together that were not open to the public. And then an ABC local news station reached out to the Committee on Open Government questioning why business was being done behind closed doors, and the Committee on Open Government issued an advisory opinion saying that because the commission was not purely advisory, they'd been given authority to decide on finalists that were going to be involved in creating this memorial, that those meetings should be open to the public. And since then, they have been made open to the public. And so that was something where a local news outlet made a tangible difference there in making committees meetings open to the public. We can move on to the next slide. This is a topic, video conferencing, that we've gotten a lot of questions on, both during the pandemic and post-pandemic. I mean, as everyone knows, during the pandemic, in-person meetings were suspended for health reasons. Everything went to video conferencing. But since then, the legislature has really wanted most meetings to be in person. And so there's laws that were passed in 2022 and that continue to be in effect related to video conferencing, to allow, to some extent, video conferencing, but to still encourage meetings that are in person. And so there was this law passed in related to the 2022 budget, expanding the use of video conferencing under extraordinary circumstances. And we'll talk a bit about that further. And it's in effect until July 1st, 2026. And I assume at that date, it's either going to be extended again, or they're going to have to come up with something else, because, you know, video conferencing is not going away at this point, post-pandemic, as many of you know from your jobs. We're doing that every day. Okay, let's move to the next slide. So now there's two video conferencing options that public bodies can take advantage of. One is the traditional option that was allowed prior to the pandemic, but not that many public bodies used, and that's connecting multiple physical locations open to in-person attendance. And so you could have someone in Buffalo, someone in Albany, and as long as they were in locations where the public could attend and there's enough room for anybody who wanted to attend, that was allowed prior to the pandemic, is allowed now. There's a new option. This is the one that was passed in 2022, which allows somebody from a private location, you know, from their home to join via video conferencing under extraordinary circumstances. And that's only allowed if your town, your village first adopts a local law, if it's town or village, if it's another agency, a resolution, after holding a public hearing and issuing written procedures governing attendance. And those procedures have to describe what counts as an extraordinary circumstance. In the law itself, it lists examples of that, which include disability, illness, caregiving responsibilities, or other significant or unexpected factors. My reading of the law, although this hasn't been litigated, is that it would not include just work issues. So just wanting to, because you're traveling or something like that would not be enough to meet this bar. But again, it hasn't been litigated yet. The other thing you have to keep in mind here is that there does need to be a minimum number of members present in person to fulfill the quorum requirement. So you could not have, if there's 10 members of a board, you could not have 7 that were joining remotely. That would not be allowed. Another issue that happened often during the pandemic, it is no longer allowed, is you can't have somebody joining via video conferencing and off camera. Members of a public body have to be heard, they have to be seen, they have to be identified, cameras have to be on all the time, volume has to be up, their name has to be typed in, and minutes need to reflect that they're joining via video conferencing. So if you're seeing any issues with that, that is a violation of the law if they're not following those rules. They're also required, if they do use video conferencing, to put that up within 5 days following the meeting up online, and also allow members of the public to join via video conferencing if they have members of the public body also joining via video conferencing. Okay, great. We can move on to the next slide. Okay, executive sessions. Executive sessions has been a highly litigated topic. It's good to keep in mind with respect to executive sessions that the law really prescribes these to where there's only 8 reasons why you can go into executive session, and several of them are hardly ever used. So the ones that come up very frequently, I'm sure you've heard often in the boards that you cover, discussions regarding proposed, pending, or current litigation. But one good thing to keep in mind there is it's not meant to allow them to discuss anticipated litigation months into the future. If it's not pending litigation, it needs to be really close to filing. It needs to be like a notice of claim, something like that. It's not a catch-all for them. Another one that comes up frequently, although oftentimes boards will refer to this as personnel matters, which they should not do. That's been litigated and not allowed, but they are allowed to go in to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, or suspension of a particular person or corporation. So an example of something that would be appropriate for them to do is to say they're going into executive session to review resumes for job openings in a particular department. That would be appropriate, but not just to say we're going in for personnel matters. That's not sufficient. And if you hear that, you can speak up and ask for clarification on that. Another one that comes up fairly frequently is the proposed acquisition, sale, or lease of property as well. Another good thing to keep in mind is, and this happened for a couple of boards that I covered when I was a journalist, finding out that they were holding secret executive sessions separate, from an open meeting. And in my cases, it was before the open meeting to line up votes. That's not allowed. They have to first start in an open meeting and then go into executive session publicly and identify the subject areas with particularity, so that the public knows that they're going into executive session for an appropriate reason. And then I have up on the slide here what specifically they have to do when they go into executive session. Okay, and we can move on to the next slide. This is just a reminder that public bodies are required to give you as the news media notice of every meeting 72 hours prior to the meeting, unless it's an emergency meeting. And if it is an emergency, and in that case there really needs to be good reason why it's, they're hosting a meeting at the last minute and not just that they felt like calling an emergency meeting, then they need to do it as soon as practicable once they've determined that they're going to hold an emergency meeting. But otherwise, they should be giving you notice 72 hours in advance. And if not, that's a violation of the open meetings law. Okay, we can go to the next slide. Great. This is minutes. This is just a reminder. This is a relatively new addition to the law that now minutes must be made available within 2 weeks for any open meeting and within 1 week for an executive session. For executive sessions, I'll note that they are only required to do minutes of those set executive sessions if a formal vote is taken during executive session. But this was a welcome change to the law because, some boards would take several weeks or months to get their minutes up, which, at that point, they're certainly no longer useful to most folks. So it's nice to see that this change was put in place. Can move on to the next slide. Open meetings law until relatively recently had what we would refer to as baby teeth. Attorneys' fees were entirely discretionary. Now, for example, if a body engages in substantial deliberations in private that should have been public, attorneys' fees are mandatory, although I'll note there is a caveat for discretion to determine if there was a reasonable basis to believe that a closed session could have been held, and some courts are fairly deferential, to a public body on that front. Second, if closed discussions were followed by a decision, the court has the ability to nullify that decision. Third avenue for relief, court can order that training will be given by the Committee on Open Government. The bill that went to Governor Patterson on this issue originally actually stated that a court could fine a public body for violating the law, and he vetoed that relief because he said, who's going to be paying the fine ultimately? Not the board members violating the law, but ultimately likely the public. And so that was why that was nixed at the time. Well, we were hoping to be done a little bit earlier, but we're a few minutes close to 8 o'clock now, but we welcome any questions that folks have.
Great. Thank you, Heather. Thank you, Michael. That was very enlightening. I'll throw a question at you. In addition to executive sessions, something that's really frustrated me has been this excuse of getting legal counsel. And I keep trying to, maybe somebody could email me later what the movie is, but there's some movie where people want to discuss what crimes they're going to commit. So they have a lawyer in the room, and the lawyer's just there as window dressing, just so, the cops can't listen, but really the lawyer doesn't need to be there. They're just having a discussion. Not that I'm saying that boards are trying to talk about illegal activities, but sometimes they will deliberate on legislation, and their excuse is there was an attorney in the room, and therefore it was a meeting with counsel. And what I discovered in the past year was that a meeting with counsel doesn't even fall under executive session. If a board wants to have a meeting with counsel, they do not need to have a public meeting, vote to enter executive session, conclude the executive session, come out of the executive session, end the public meeting. There's no notice requirement that this meeting was ever held. But you could have a 5-member board where they meet, all 5 members, or at least a quorum, with an attorney, and that can be exempt from open meetings law. What's really difficult is the recourse. How do you prove, unless one of those board members goes to the media and says this was really inappropriate, how do you go about convincing a court that deliberations were in fact happening that should have been happening in public? And then how do you get any satisfactory recourse from that? If you win that lawsuit that says they were deliberating privately, and you're probably not going to get any attorney's fees out of it anyway, even when you win that lawsuit, like where's the satisfaction in that, or how do you even get a guarantee that's not going to happen again?
Mm-hmm. And I will say that's oftentimes the issue with the open meetings law is getting satisfactory recourse. But you are raising a significant issue, and that's attorney-client privilege. And you're exactly right that it only covers. It's not any time that they're meeting with counsel that it should be covered. It's only when they're meeting with counsel to seek legal advice. And it's not when they're seeking business advice, it is legal advice. But proving it or even knowing about it, right? You basically need to have somebody that's leaking that to you to know about it. And so that is a significant issue. And I'm glad you're raising it. But again, the recourse, if it was brought to court, you could, if there was a decision made during that session, you could get that nullified. You could get a court to say that they violated the law. If it was egregious enough, a court might order attorney's fees. That's the extent of what you would likely get. But good question that you raised.
And we have a question that came in from Roxy. They're referring to Glen Cove here on Long Island, saying that their executive session always happens after their council meetings. This is how it's listed on the agenda. Is it appropriate? And it just says executive session to discuss the medical, financial, credit, or employment history of a political person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. So it's
It
kind
is
of,
not.
yeah.
It is, I will tell you, it is not appropriate. And so that's just quoting verbatim what the statute says. And that's not appropriate in part because I would guarantee you almost never be a time where you would be meeting an executive session to talk about all of those things at the same time, right? So it needs to be more specific than that. It shouldn't just be parroting the language of the statute. So no, that's not appropriate. And I would suggest raising that with them the next time you're in a meeting and asking for more specifics. So.
So a committee that I reach out to often is the Committee on Open Government, which is a New York State agency, and they can provide pre-existing opinions that they've put down in written form when people have had similar questions in the past. And then I might take that to a village or a town or some agency that has denied my FOIL request, and I want to tip the scales of my appeal by showing like, hey, this has been talked about before. But when is it appropriate or merited for a journalist to reach out to your group? Because you're not a state agency, you're not under any obligation to help out a journalist, though it is why you exist. At what point should somebody be at in their frustration over FOIL or open meetings law where they reach out to you or Michael for advice?
Mike, do you want to take that?
Yeah, so we're happy to talk to people at any point. Even at the very start, when people are trying to formulate their FOIL request, we're happy to take a look at it or troubleshoot or just think through what the request should say. But most often people come to us once their request has been denied or they've had to wait an unreasonable amount of time and they want to file one of those administrative appeals. So we can help with that, or at a later stage, filing a lawsuit if you've already done the appeal and the agency's denied it. But really, at any point, we're happy to talk to people and figure out what to do next.
Mm-hmm. And then how do you get your funding? Is it just something that the university throws in for? Is it students at your university that's helping you along with these things, or are you two really on your own?
So funding does not come through students, although students do assist with some of our work. And funding also doesn't come through the university. We have several foundations that fund us. And so we're continually fundraising on our end. And so that's where that's coming from. And we do for some of our suits get attorney's fees. So some funds come that way, but it's largely funded through foundations. Some of them also fund news outlets like the Knight Foundation, for example. And Knight funds folks like us because Knight understands that without legal support, it's oftentimes hard to do hard-hitting investigative work. There are some FOIL requests that would never get fulfilled without a lawsuit. And so like Revson Foundation funds Mike's work in the New York City metro area. They're great. Legal Clinic Fund also funds part of my work and part of other legal clinics work as well.
So I do want to say some cheery things. One of them is we've worked together and we've had success. We actually had a pretty big success shaking loose a video of a police officer being investigated by his police chief after being in a car accident. That the circumstances of it and how it was handled was very questionable, and I'm very grateful that you intervened there. Sometimes just having an attorney write that FOIL appeal on your behalf rather than write it as a journalist can really make people snap to attention who would otherwise ignore you. But I wanted to ask, where do you think our lawmakers could most improve FOIL and open meetings law to ensure that when you put a FOIL request in, it's not just getting kicked down the road indefinitely until you don't even need that information anymore?
Yeah, go ahead. You can start, Mike.
I was just going to say for FOIL, I think putting a hard deadline in for the agency to respond. So rather than the law saying they have to respond within a reasonable time, giving them 20 days would be helpful, just like the federal law does. Agencies still ignore that, but at least then as a requester, you have a hook to say, no, it's been more than 20 days. I need the documents now.
Yeah, I think that's exactly right. And with respect to open meetings law, we talked a lot about the video conferencing issue. I think, having a provision in place that secures the right to hybrid meetings is really important. Because I think as for those of us who cover public meetings, in the past 20 years, 30 years, there's been a precipitous decline in the, number of people who actually go physically to public meetings. But that number went up significantly during the pandemic with video conferencing. And there are many boards across the state that are just doing in person now and no longer doing video conferencing as an option at all. Which I think really is hurting public attendance.
So something that ties in a FOIL is retention requirements, where I had a FOIL situation recently where somebody was taking notes in a meeting that seemed to be pertaining to a vote, but when I asked for those notes at the end of the meeting, I was told that they no longer exist because they weren't retained. And it was kind of arguable about whether they really needed to retain notes that were being passed back and forth between a quorum of a board during a public meeting, which I would think kind of in the spirit of the open meetings law should be public. But I always get disabused of these notions when I go to the Committee on Open Government and I ask for things that just feel like they should be open and public. But so I run into these things where I quickly get disappointed in these laws and find them lacking. Since you're so involved in this day in and day out, what do you think the biggest misconceptions are that people have about FOIL and open meetings law? And then, maybe if they knew that stuff in advance of filing their FOIL requests or objecting to a closed meeting, they might have better luck if they knew that.
Mike, do you want to start with FOIL?
Yeah, I
Anything?
think I think the biggest one is just the specificity of the request. I think oftentimes people um, will ask for documents kind of in the way that they would talk to a source, right? Just ask for documents in kind of a human way, rather than being really specific and narrow to get the agency to respond faster um, and then down the road, if they don't get the documents, to have a stronger legal argument.
Mm-hmm. Yeah, and for open meetings law, I think the biggest loophole really is executive session and holding people to account on that, on actually requiring agencies to, with specificity, say why they're going into executive session and ensuring that they're not going into executive session at inappropriate times, like right before a meeting. I think that's the biggest one for open meetings law.
Other than going to court and filing an Article 78 lawsuit, is there any sort of an authority that is there to actually chastise or discipline um, a, a government agency when they're not adhering to these laws?
I mean, there's there's the Committee on Open Government, but as you know, that they just issue advisory opinions, right? So that's can be some level of chastisement, but I think more so if a news outlet, like yourself, publishes an article about an advisory opinion that went your way. It used to be under the old director of the Committee on Open Government, Bob Freeman, that back when I was a journalist, he would occasionally adjudicate issues that between myself and an agency that I was covering. If we had a dispute, he would just get involved. The Committee on Open Government does not do that these days, to my understanding. Really, they'll issue advisory opinions, and they don't as often comment for stories. Like Bob used to do that too. He'd comment a lot for stories, which would be helpful because then you could quote in your story, Committee on Open Government says you're violating the law, essentially, and that might be enough to shake loose documents without having to go any further. Of course, we're happy to weigh in on something like that for a story if folks think that would be helpful in appropriate cases too.
On the records retention front that I mentioned before, a record could be a text message or an email. And these days we have, you could send somebody a disappearing voice message over text, right? If you're on an iPhone, you could also use, I think Telegram's the name of the app. There's things like Snapchat where you send disappearing messages. Where I'm hoping a lot of a lot of politicians are not adopting like Snapchat as a means of communicating to destroy records. But where's the recourse when you have people using these means of disappearing messages for messages that we know fall under FOIL? They don't fall under an exemption. We should have access to those messages if we file a Freedom of Information request for them. But people are purposely using disappearing messaging apps. Can we do anything about that? Like once you learn about it, who do you even complain to get them to stop?
Yeah, that's a good question. That could be a situation where I mentioned at the top our Streets Blog lawsuit against DOT, where we're claiming the agency has a policy or practice of violating FOIL. So we're trying to get a court order requiring them to stop. That could be another situation where you say they have a practice of violating FOIL and the court needs to order them to stop. Because otherwise, I'm not sure there's much recourse. FOIL applies to any government records, which are any records created to do government business, and it doesn't limit itself to only records created on like a government laptop or something. So just because an official is using their personal cell phone and going on Snapchat or something, if they're conducting government business on Snapchat, that should still fall under FOIL. But yeah, once the records are gone, they're kind of gone. There's not a lot more you can do besides maybe get a court order requiring them to stop doing that in the future.
Well, we're in overtime here, so I do want to let you go. But is there anything else that you want to mention for our guests and the people who watch the recording later?
I think just to reach out to us if you have questions.
Yeah, exactly.
And thank you for having us.
Yeah, well, on behalf of the Press Club of Long Island, we're very pleased that you took the time out of your day to do this. And for anybody who missed the beginning or they just want to rewatch this, we will throw it up on our YouTube channel in the coming days. I'll also throw it up on our Facebook page. That's Press Club of Long Island on Facebook, PCLI on Twitter, Press Club of LI on Instagram. Heather, Michael, thank you so much again for doing this. You've been invaluable. I know that to me personally, in the work that I've done, you've made a huge difference in what we've been able to obtain and shake loose, and it's turned into some pretty extraordinary articles that we might not have been able to do otherwise. And everybody in our audience, thank you for joining us. We can't do these events without you. You can learn more about the Press Club of Long Island at pcli.org. We do have an upcoming event in November that's going to be a look at the election and how it turned out. And we're hoping by the time that event is held that we actually know what the election results will be. If we don't, then we'll have a much different discussion. So visit pcli.org in the coming days to learn more about that. Okay, good night, everybody.
Thank you all.